Here are three ways to screw up cross-examination. You want to know what they are? Come join me for a moment as I share with you some great information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. The first way to screw up cross-examination is by not asking leading questions. The second way to screw up cross-examination is not to listen to the answers that the witness is giving you. The third way to screw up cross-examination is to argue and fight with the witness. So what do I mean by all this? All right, you should know that during cross-examination, the only way that we are supposed to be asking questions, or the only way we should be asking questions, is with short, leading questions. Doctor, isn't it true you graduated from this school? Yes. And isn't it true that on this day you saw this patient? Yes. And on that day the patient complained of the following things. Isn't that true? Yes. What I'm doing is I'm asking the doctor short leading questions because I only want him to say yes, no, I don't know, or I can't answer the question. That's it. I'm the one telling the story, and I either want the doctor to agree or disagree with the statements that I'm making. The second mistake that a lot of attorneys make is that they're so focused on thinking about what to ask next or what to ask in 2 or 3 questions ahead that they don't pay attention to what the witness is actually saying. And you can get some great nuggets of information to then use to continue asking great cross-examination questions if you only listen, carefully listen to what the witness is actually saying. The third way to screw up cross-examination is to fight with the witness. Now, you see attorneys do this all the time. They get into pissing matches with the witness over the wording of some specific question. You ask a question, doctor, isn't it true that it's important for a physician to keep accurate records? Well, I don't know exactly what you mean by accurate, counselor. Doctor, isn't it true that it's important for you as a treating physician to keep thorough and detailed records? Well, it all depends on how you define thorough and detailed, counselor. Yes, now we're getting into a pissing match where the doctor is now going ahead and arguing over the specific wording. And there are different ways to control that and different ways to address that to show the jury that the doctor is being unreasonable. Now, if I go ahead and continue to fight and argue with him over nonsense, you know what happens? Many times, the doctor who's on the witness stand being cross-examined will actually develop sympathy because I'm now going after him over and over again. And you know what? The jury at some point feels bad for the doctor, and they don't even realize it. And the attorney doesn't even realize what he's doing. If you can avoid having to directly argue and fight over specific wording, and semantics, you are much better off. There's a much better way to control the witness. So I'll give you an example. At the very beginning during cross-examination, I will often ask the doctor, Doctor, I'm going to be asking you a series of questions that call for either yes or no, or I don't know or I can't answer. If you find that you cannot answer the question the way I've phrased it, please do not explain. Is that okay? Will you do that? You just simply answer yes or no. And if you can't answer the question, do you promise to answer, I can't answer that question the way you phrased it? And I will then ask another question, okay? So in that instance, now when I go ahead and ask a question and the doctor starts to explain away his answer about why he cannot answer the question, I'm going to stop him and say, Doctor, let me stop you for a second. Do you remember a few moments ago? You made a promise to me. You promised to answer my question yes or no, or I can't answer the question the way you described it, the way you phrased it. And you promised not to explain anything. But yet you just gave an explanation. Let me ask the question again, doctor. And now I continue doing that until the jury understands, the doctor understands, that continuing to do that will get him nowhere. So these are the 3 ways to screw up cross-examination in a medical malpractice case here in New York. You know, I realize you're watching this video because you likely have questions or concerns about your own matter. Well, if your matter did happen here in New York and you're thinking about bringing a case but have not done so yet because you still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know I answer questions like yours every single day and I'd love to talk to you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a wonderful day.